So I'm going to be talking about understanding the relationship between the use of care and care proceedings. And this we'll see is quite often hidden in the data or confused in the data. And the work I've done is coming from my outcome study, and I'll talk a little bit more about that later. And on the screen, you see the names of the other people who worked on the study. And we had support, apart from the ESRC, from CAFCAS, who you'll see are a very important source of data in this area, and from the Department of Education likewise. So I'll talk a little bit at the start about the data sources, just to clarify. And then I've got 5 separate issues I'll be talking about. Obviously, they're all connected, and you'll see as the slides go through when we move from one section to another. So we'll talk about entry to care and the legal mechanisms, and you'll be aware, or those of you who deal with social care data will be aware, that the data is divided into entry, the census data, and leaving care. And I won't be talking in detail about leaving care, although I will be talking about leaving care curves. I'll talk about the legal status of children during care proceedings, and that data comes largely from the outcome study. And talk about court orders and leaving care, again from the outcome study. And then a little bit more about the impact of reforms on care proceedings and the care population, and then some data issues. I can answer technical legal questions about the case law, but that I don't really know who the participants are. So if you're really a care proceedings legal nerd, you can ask questions, don't want to bore everybody else, but you can always contact me. I think you'll find my email on the University of Bristol website. So the data sources from the study, this gives you an idea of the size of the study and what we actually did. And there's an infographic that follows it that shows it a little simpler. So we had data from court proceedings, which we extracted from court documents. It's not possible at the moment to do that automatically, and certainly in the detail we did it, you couldn't do it automatically, but there is some possibility of automatic, or there will be some possibility of automatic extracting in the future. We linked that to the Department for Education, SIN and LAC Data, the CLA database, and with their equivalents in Wales. And we had very high linkage rates. For our first sample, 90%, and for our second sample, 99%. And that was because we used a deterministic method of linkage. We got the local authorities to identify for us the cases in our legal sample. We told them which the cases were, and they gave us the number for which they submitted to the DfE the data about the child in their annual returns. In total, we've got 616 children, roughly equally between the two samples, and we've got 373 cases. In legal analysis, it's really quite important to distinguish between cases and children. And to clarify, and the data isn't always very clear about this, not ours, I mean the published data, about whether they're talking about cases of children. And it operates as a natural experiment. We'd already collected data for another study before the PLO reforms, and we went back to the same local authorities to collect a similar random sample after the reforms. And this data comes from the south of England and Wales. Now we know from another study, not ours, a study by Judith Masson, that the practices in different parts of the country in terms of the courts are different, and we know also that from the DfE data and the late data tool on local authorities' provision of services. So that was our data. I'm also going to be talking a little bit about the national data on care proceedings from CAFCAS. There is also court data, but everybody uses the CAFCAS data, which tells you something about the court data. There's also data from CAFCAS Cymru. We didn't actually use CAFCAS Cymru data, except that had been published, although we are on our next study. It's similar to the CAFCAS data, and they're both available in the SAIL database, but the CAFCAS Cymru data has more data limitations. Obviously, the national looked after children and children in need statistics, and we had that sample for our 616 children. When talking about this study, one of the things that is slightly infuriating is devolution. We have a single legal system for England and Wales, and the Ministry of Justice data, some of it at least, covers England and Wales. But the CAFCAS systems are separate. The local authorities have similar duties, but the data collection is different, and particularly around the children in need data, which isn't a census in the Welsh data. It's only a survey. So we really didn't get anything from the Welsh SIN data. This is the infographic I mentioned, describing the samples. Linkage, the study was really about outcomes, so we have the outcomes 1 year after the order, and of course anything about outcomes, apart from what court order is made, anything after the proceedings out of outcomes cannot come from the court data. CAFCAS has some data on it in relation to further proceedings, but what happens to the children is only visible in the DfE data and the equivalent Welsh data. And you'll see we followed some of these children up, the earlier sample for 5 years, and we did check whether there were further proceedings. But I'm not going to be talking about that, although if anybody wants some answer questions, they can. For those of you who are not, don't read the Children Act as their bedtime reading and have only a hazy understanding of what these different powers and duties local authorities and the courts have, I've set them out here. Key distinctions are that Section 20 does not involve the local authority in going to court, and it's not time limited in any way. But it's used to be called voluntary care, and the parents can remove children at any time if they're able and willing to provide care. So that's something that the local authority has control over. Section 46 is an emergency power which the police have control over, although local authorities sometimes ask them to exercise it. Only lasts for 72 hours, but for the majority of children it's really transitory, lasting under 4 hours. I did a big study of police protection in 2000 where we looked at practices in 16 forces. Most children are not in police protection for very long at all. The children lost in shopping centres and found home alone and things like that. If they have to stay longer, they have to be accommodated. We had in our sample of 600 plus children, we had 127 children who'd been in police protection, but only 20 of those children had actually been accommodated. So that would give you like a 1 in 6 of children being accommodated. This is why we don't see Section 46 much in the census data, because very few children are there on under Section 46 on the 31st of March. 45 and 46 are emergency court orders, so the court controls this. The court can also grant different orders, and it can always refuse orders. It's often a first stage to bringing care proceedings, but doesn't have to be. And then you've got the sections that relate to care proceedings. Section 31 is the application for care proceedings. Court can make care orders, Section 33, or interim orders, which are made during the proceedings. The court can always refuse any order it's asked to make, and it can make alternative orders. And those alternative orders, like a supervision order, a child arrangements order, or a special guardianship order. So under Section 45, 46 and in care proceedings, it's the local authority that's in control. Actually, the majority of these cases are settled or handled without a full-blown dispute, but in theory at least, the court is in control. So let's look at what this looks like in the data. This is about entry to care. So those of you who are familiar with the DfE data know that entry is recorded on first entry, and then everything else, any changes in legal status, appear in the episode data. But this is from the first entry data, this is from the published statistics. What I want you to point out to you are the patterns we see in these data. Firstly, section 20, the power that the local authority has control over. We see that is the majority of children enter care under section 20 for their first entry. That proportion, or the number entering under section 20, is also declining. Care orders, the dark blue, and interim care orders. The DfE publishes these together, doesn't separate them out. They are collected separately, but they're published together. At one time they were separated out, but they're not now. So we can't distinguish which children are involved in care proceedings at the point of entry, on which have come in, the care proceedings have finished. But the vast majority of these entry to care cases will be children entering during care proceedings. So they'll actually be interim orders. And then the red is these emergency orders, and the EPOs and police protection are put together. What we see in the pattern there is there's not a lot of change in those emergency applications, emergency powers over that 10-year period, whereas care orders, interim care orders, have increased and the use of section 20 has declined. So we've actually got a really substantially changing pattern happening in the teens between use of orders and use of section 20. And if I'd taken the data back before the previous 10 years, we'd see really a much more stable pattern in the use of proceedings. We have an increase in the use of the proceedings following the Baby P case that starts around 2008, but there's other things going on here too. The other point to point out, which will come clearer from the next slide, is these are only children entering care. It's not telling us how many proceedings there are at all. And that will be particularly the case in use of police protection. Lots of children subject to police protection but never enter care. And we'll see also in relation to care proceedings. So this chart takes the compulsory entry from the DfE data, so it's adding together those red bars for emergency and the blue for care orders, interim care orders, and it's that's what's graphed in brown, and in blue we see the number of children involved in care proceedings, and that comes from the CAFCAS data. And you see there's a big gap. There's a lot of children there who don't appear to have entered care compulsorily. So one of the things to think about is this gap. Now, the entry data is about first entry. So some of the children will have entered care under section 20. So in those blue lines that are above the brown, there'll be children who are in section 20 care. But also, there's not all children in care proceedings enter care at all. And we'll see more about this from the data in the study. And my huge bone of contention is, despite it being the most expensive intervention that local authorities do, bar perhaps the use of secure accommodation, which is very rare, the use of section 31 is not recorded in the DfE data. So this, moving on then to look at what we know from the outcome study, we could look at children's legal status at the point the care proceedings started by identifying that date from the court data and putting it in the analysis of the DfE data. And we've done that for both samples, and you see the two columns for the two samples. First thing to think about are these children at the bottom. I sometimes call them the grey children. So these are children who are not in care during proceedings. Why are children not in care during proceedings? In the majority of cases, it's not because local authorities don't want to bring children into care when they start proceedings. In vast majority of cases, local authorities start proceedings seeking a care order and seeking an interim care order. But courts don't always agree. And in fact, we see the bigger grey band in sample 2 reflects an increase in the standard for making interim care orders in recent years. The courts are much more restrictive. And this was reflected in interview comments made by local authorities we interviewed and social workers we interviewed in the study. And it varied from place to place. So some local authorities said they could always get their ICOs they asked for, and some said they couldn't. And courts have also picked up on this idea that children can be subject to an ICO and not removed. Of course, those children would be in care, they would be in care placed at home. Our local authorities actually refused in these instances to have ICOs with children placed at home, and instead said they withdraw the application and seek only an ISO. And the courts then made an ISO. So it's an interim supervision order. So some of these grey children are subject to interim supervision orders, but of course they're not in care. Other children in that grey group are placed with people who either don't want to be local authority foster parents, or more usually are not accepted as local authority foster parents. They're not accepted within Regulation 24. And the court will then support the care by a relative usually, and make an interim child arrangements order. And that of course means that the local authority has no powers in relation to the child. Sometimes the court also makes an interim supervision order, but not automatically, where they are actually supposed to. So those are the grey children, children who are in care proceedings but not in care. The darker blue children are children who are subject to Section 20. So despite all the complaints from senior judges about the abuse of Section 20, a substantial number of children are Section 20 throughout court proceedings. And this happens because if the parents agree, and it's usually with pressure from their lawyer, to accept Section 20, then unless the local authority's got a good reason for wanting an order, wants parental responsibility, the court won't grant a court order. And so children remain Section 20. And then that group is also growing. And certainly in our London authorities, where the courts were under particular pressure, if there was a Section 20, the local authority was quite likely to be willing to continue it rather than seek an order. The pale blue children entered under Section 20, but then an ICO was granted, and the yellow group entered purely by an ICO. So we see then the breakdown, which is not visible in the DfE data, of what happens, children moving through the system, if you like, changing their legal status at a particular point in time during the course of the proceedings. So I'd like to move on now to look at the orders made in the proceedings. And what I've done here is to separate out children who are looked after, so the children in the blue and orange group from the previous slide, and children who are not looked after, in other words, the grey children. And I've put both my samples together so that I've got as big a sample as I can have out of my data. And I'm presenting percentages. So the number of children in the columns is very different. And you see on the screen, on the slide, that the not LAC group are 121 and the LAC group are 472. What you see then, or you should see, is that the pattern of orders is very different for these two groups. The other thing you see is that the vast majority of children who enter care proceedings leave with some sort of order. Yes, it looks like quite a lot in the non-LAC group, but remember that's 12% or whatever it is 12% of 121. And the 1%, 2% in the LAC group is 1 or 2% of 471. So we're talking a very small number of children who don't end proceedings with a court order, but you don't always get what you ask for. I've got another slide which I'll show you later about how the court orders changed over time. Other thing to know is what these different orders are for those of you who are not geeky care proceedings people. So the pale blue is supervision orders. So this is local authority involvement without children being in care. And if you like, it's the lowest level of involvement in child protection once proceedings have been used. The pale green are children subject to a child arrangements order, and most commonly a child arrangements order with supervision order. These are children who are actually placed with a parent, or with a parent, sometimes a different parent from the parent they were with when the proceedings were started. So this is effectively a supervision order, but we're also clarifying the parental responsibility element, which is why a child arrangements order is made. So that group, 70% in the not LAC group, are all effectively at home with parents. The dark green group are children who are subject to special guardianship, and special guardianship means they're in the care of relatives. It's a long-term, perhaps a permanent order in the care of relatives. Child arrangement orders used to be used for care by relatives, but since special guardianship orders have been invented, there's a really strong divide, at least there was in our data, between placement with relatives and placement with a parent. The yellow are the care orders, and the red are placement orders. So this is the court has approved a plan towards adoption. Technically, a care order is also made when a placement order is made, but I've put those two, I've separated those out. So the care orders are just care orders, and the placement orders are seen just as placement orders. And another way of looking at these stacks is that the orders get more serious as interventions as you go from blue through to red. Now let's just look at that slide again, but just clarify what the child's transitions are in relation to the DfE data, the looked after data, and the SIN. So we can see the vast majority of the children in the not LAC group are SIN only. They're only children in need. But a small proportion, I think it's 21 children in total, enter care at the end of care proceedings. These children only enter care when care proceedings are completed. In the looked after children group, obviously they're all looked after, otherwise they wouldn't be in the looked after children pile, but they leave, the ones at the bottom, below the green and below, leave care and are only children in need subsequently. And we did find actually that almost all the children were in the children in need database in the year following the care proceedings ended. And then the group in yellow and red the children in yellow and red, remain in care. They were in care during the proceedings and they remain in care when the proceedings end. So that gives you a sense of how children are moving through these databases. Using that data, we're able to look at leaving care curves. On the left, we have the standard traditional leaving care curve for all children who are looked after. And this comes from Sinclair's and colleagues' study of children in the care system. So Sinclair didn't separate out children by legal status. It's actually really quite difficult, particularly when you don't know when the proceedings take place. And it shows that how children leave days after admission. So we get a very swift leaving in the first few days after proceedings, after children have entered care, and then the rate of leaving declines over time. And the data is right censored because obviously to finish the study. The right-hand chart is from our study, so it's only showing children who are looked after under during care proceedings. It's only the LAC group in care proceedings. And it shows the two groups separately, sample 1 and sample 2, and it shows when they leave care. And we see a sort of cliff face shaped graph, and it's a cliff face shaped graph around the final hearing. So what we did was we standardized leaving care around the date of the final hearing. So we had a variable final hearing and we put that in and then ran the analysis in that way. Some children leave slightly before the final hearing. You've only got to put one date in for the final hearing. It might be a number of days, over a weekend, for example. Child might be returned home because that's what the court has said they're going to decide, so it's going to be arranged right from the beginning. Some children return to their parents or go to a relative under a child arrangements order or with an interim supervision order before the final hearing, because that's what's going to be agreed with an SGO, for example. And some children just leave care when the final hearing ends. A few children stayed in care immediately after the final hearing in section 20, until placements with relatives or parents could be finalised, housing issues, that sort of thing. And then you see in the 6 months after the final hearing, there's almost, or in the, not the first month, but the following 5 months, there's almost no change. So children leave at slightly before or at the final hearing. And then if they don't leave then, they largely remain. So we can come back to that in a while, but this is data from the census, the census of looked after children, showing the different legal statuses. So section 20, care orders, which includes interim care orders, and placement orders or freeing orders, which are in red. We can see the patterns that come out of these law reforms. So the law reforms I'm talking about, actually I've set them out on the next slide, so it might be better to go here. Rabies reduced the number of placement orders. The court stressed the importance of adoption being a last resort. This was well known, well established already, but re-emphasis of that. The PLO, the reforms to reduce the length of care proceedings, increase case management, reduce the use of experts in 2014. And then Ray N is actually one of a series of cases which attacked the use of Section 20 by local authorities. So we can see the use of Section 20 declining over that period. We can see the use of placement orders declining following Ray BS, quite a substantial decline. But we can't see anything about how the PLO has really impacted on care proceedings. We can see more care orders, but the PLO shortening care proceedings, having shorter ICOs, isn't visible at all. Partly it's because of more care proceedings, partly it's because of fewer placement orders, but there's just no way within the DfE data to identify that interim care orders are lasting less time. So we again return to the data from the study. The chart on the left compares the first sample and the second sample for the duration of the proceedings. And you can see the proceedings are pretty well halved in duration. Slightly over 26 weeks average for sample 2 and slightly over 52 weeks average for sample 1. If we look now at the data, it wouldn't look, published data, it wouldn't look so good because proceedings have moved up before the pandemic to, I think, 33 weeks, and they are only going to take longer because of remote hearings and things like that. Although the number of applications doesn't appear to have declined, at least from the CAFCAS data that was published for April. So that's how the reforms impacted on case length, as shown in our study. And the second chart, the chart on the right, shows how the reforms impacted on court orders, and it's using the same colours as I used in the other chart. One thing to say about this is that the PLO was not expected to change court orders at all. So we could say this is about Ray BS, but thinking in more detail about decision making, if you have a year to make a difficult decision, or you have 6 months to make a difficult decision, you might find it easier to make that difficult decision over a year than you do over 6 months. In other words, you might feel that after only 6 months, when we're used to having a year, we could always think of more information which would help us really make sure that this is the right decision. And until we know that the decision we're going to make really is right, maybe we'll take a less serious action. And that would explain perhaps the increase in supervision orders, judges giving parents another chance because the information that they have doesn't really seem absolutely to justify a care order. Another element in that is that parents often participated throughout the sample 2 cases, whereas in sample 1 cases, the length of proceedings, a lot of parents dropped out. And if parents aren't there at the end, they're not going to get an order in their favour. That's a supervision order or a child arrangements order. What we see in that chart on the right is that the number of Placement orders has halved. Number of care orders is very slightly down. Number of SGOs, proportion of SGOs has gone up substantially, almost doubled, not quite. Child arrangements orders almost the same, and a big increase in supervision orders. So putting it around the other way, we have an increase in lower, less interventionist orders in sample 2 compared with sample 1. And there was no suggestion in the reform process that that was intended. And the pilot study to look at whether the process would work didn't find any difference in the orders made. So just thinking about a summary of the impacts of the legal reforms on care. And we have to put that this is all in the context of an increasing number of care proceedings after the Baby P case, which we can't separate out. We can't know which cases would have been brought even if Baby P hadn't happened. What we can say, though, with a fair degree of certainty using a number of different sources, is that the threshold for intervention did not decline as care proceedings increased. One might think about it in this way, that cases are going through the care proceedings more quickly, and that perhaps creates opportunities to present cases, to prepare cases, which would have been waiting before being issued. And we certainly in our first sample had cases stacked up in local authorities where the legal department didn't have the capacity to prepare the application because it was already working at capacity. So thinking about the impact on the care population, shorter proceedings mean that many children spend less time in care during proceedings. So we have all those children who are in the LAC group who leave care at the end of proceedings. And we see that there are more children leaving care at the end of the proceedings from slide 14 because there are fewer children subject to care orders or care and placement orders at the end of proceedings in sample 2. So proceedings are shorter, more children leave at the end, they are spending less time in care during the proceedings. But there are fewer placement orders, so fewer children are going to leave care after the end of the proceedings, in the 1 to 3 years after the proceedings. So if you don't leave at the end of the proceedings, you're likely to be in care for a prolonged period of time. And in our sample, the children left who weren't adopted left because they aged out of the system. There was not a big practice of reunification. If children were being reunified, they were being reunified at the end of the proceedings. And they were being reunified then quite quickly because the proceedings had lasted less time than they would have done in previous years. So we could also see that as the care system is dealing with more children cycling through. There are children who are subject to orders or in section 20 during proceedings, but who leave care at the end of the proceeding, only to be replaced by more children as more proceedings are started. We certainly know the number of proceedings that's gone up. We also know that, as I said before, more children children who don't leave at the end of the final hearing will remain in care long term, but there's more demand for support because special guardianship, supervision orders, all require ongoing support from the local authority. For local authorities, there's more pressure. The courts become more demanding. more of the assessments are supposed to be done before proceedings. There's fewer assessments in proceedings. Courts try to impose rigorous timetables, which in our study led to some of the assessments being really curtailed in order to meet the court timetable. For example, an assessment of an SGO carer, a full assessment, not just a preparatory assessment, but a full assessment being done in 12 days. And at the end of the 12 days, it was ready for the final hearing, and the child who hadn't been placed with those carers during the proceedings was placed with them at the end of the proceedings. And we certainly had a number of children, about a third of the children in SGO care, who had not lived with their SGO carer before. Half of them hadn't lived with their SGO carer before the SGO was made, and a third of them who in that position, the assessment lasted 10 weeks or less. So quite a lot of pushing children through into new placements with people who we might describe as relative strangers. And then local authority require fewer adoptive placements, but they have to find more placements overall. And then finally, to consider the data issues. The legal basis for care during proceedings, that was my slide 7 with the grey, blue and yellow. As I say, my bone of contention that the use of proceedings is not a variable in the administrative data, and you can only identify the grey children in care proceedings by linking with the SIN data. That's important because the Ministry of Justice has undertaken a data linkage process using the CAFCAS data for the children in care proceedings and some DfE data. But they don't link to SIN. So they don't know anything about children who are not looked after, only about certain orders made. The other problem with the Plato and Watch tools is they only go up to 2017. They're 2010 to 2017. It's not clear they're going to be updated. Local authorities, children's social care, don't, in my experience, collect data about the proceedings, but that is collected in their legal departments. And I have been involved in a project trying to link those two data sources together. And we did find that local authorities often use different data systems in their legal departments and in social care, but some of them are now moving towards having a common system rather than having what was usually just an Excel spreadsheet in the legal department. And then the problem of combining ICOs and care orders in the DfE published data. Children in proceedings but not in care are not identified in the DfE data. Most of them are children in need. And supervision orders quite a big substantial part of local authority activity, but supervision orders are not recorded in the DfE data. Just these children are just children in need. And that's also problematic because what we see is that quite a substantial proportion of children who are subject to supervision orders are subject subsequently to further care proceedings. So these supervision orders made are particularly after short proceedings, but also after longer proceedings, are often made and are not effective in improving children's care. And Judith Masson, who did a big study of supervision orders, found the same thing. About 25% of the children are subject to proceedings subsequently within 1 to 3 years of the original supervision order. Children who leave care at the end of the proceedings, there's quite a lot of misrecording of the reason the episode ceased. When children leave care to an SGO, there's a lot of lack of clarity as to whether their carers are former foster carers or not. Some local authorities seem to record only former foster carers as people who were their foster carers before the SGO, so people who've been approved, whereas actually the key thing is whether the child is leaving to somebody who has been caring for them. So relatives who've been caring for children who are Regulation 24 rather than approved foster carers are sometimes said not to be former foster carers. What we found actually was that where SGOs are made at the end of care proceedings, children are always going to relatives. Whether those relatives are former foster carers or not, with their Regulation 24 carers or approved foster carers, they're not going to stranger foster carers. We haven't looked at SGOs made at a later date. We didn't have any of those in our follow-up data. We found adoptions made up to 5 years after the care proceedings, but we didn't find any SGOs made. But that's perhaps unsurprising because SGO practice for our sample in 2009 was really undeveloped. There were fewer SGOs being made with that sample. And the other thing is cohort analysis. If we look at different cohorts, we can see the impact of law changes. We'll be able to see the impact of COVID. We can see the impact of local authority policy changes. But the data that's published doesn't identify cohorts of children. It identifies populations of children and those who enter the system, their first entry. CAFCAS does have cohorts in terms of it follows through the number of applications, publishes applications each month. And it does actually, is able to identify which local authority is involved in each application, but it only publishes rates of applications by local authority by 10,000 child population, and that's the information that goes into the late tool and rather than numbers. Most court statistics are just snapshots. That's really important too, because if you look at the applications and you look at the orders, they're not the same children. They're applications made in a particular year, orders made in a particular year, and you cannot trace the children through. The Plato tool does allow you to do that, but as I say, it's only very limited. So the fact that we don't link applications to orders means that in the national data, we can't look at success rates or outcomes, but in proportions. So that's really, I mean, I could go on and complain about the data for a long time, but I won't. More about the study, you can get the research report, and there are some summaries of different aspects of the research report on following that link, and open access paper on data linkage, which I wrote with my colleague Ludwine Garside and Sean Jenny from North Yorkshire County Council, where we actually carried out a trial to see, or a pilot exercise to see whether an approach I developed for linking data that local authorities could use would work. It does. And there's some references. So thanks for listening.
Thank you very much, Judith. That's been absolutely fascinating for someone who teaches academic child protection law to actually see the statistics of what happens in real life. We have lots of questions and we'll get through as many as we can. Starting off with who says, does the data suggest that children who previously would have been accommodated through Section 20 orders are now becoming subject to interim care orders? And he follows that question up with, he's surprised that Section 20 continues through the largest point of entry to care.
Again, break that question down a bit. The number of care proceedings has gone up. I would suggest that some of those children would have remained in Section 20 and not been subject to care proceedings. So that suggests, yes, that there's less use of Section 20 and more use of care proceedings. And what's more, there's less use of Section 20 and more use of care proceedings. And in that less use of Section 20, actually more of those children are subject to care proceedings. And between our two samples, we saw actually an increase in Section 20 children in care proceedings. So I think, yes, I think I better stop there.
Are you surprised, I suppose, from the point of view of government intentions for the different orders, that Section 20 continues through the largest point of entry to care?
Not at all, actually, because Section 20 is there for a whole range of different things. A lot of it's short term or relatively short term. I think lawyers, and particularly the judiciary, know about care proceedings, but they have very little understanding of what else local authorities are doing that isn't about going to court. So they don't know about care for children in crisis that doesn't need proceedings. They don't know about long-term care of children where parents are working with children's services but can't cope with the difficulties of a particular child. Courts have much less dealing with older children, children aged 14 and above. And those are the children, they're the biggest group of entrants into care, are teenagers, and they're mostly entering under Section 20, because local parents aren't saying, we don't want our child to go into care. They're saying, please take our child, please take our child. And the local authority is saying, no, you can cope with this child at home, we'll provide you a bit of support. So it's not surprising at all. I think the court focus tends to be on the under fives, and certainly under fives are the biggest group in care proceedings. Over 50% of children in care proceedings are under 5.
That's very interesting. I have a very legal technical question from he thanks you, and he says, do you think Williams and Hackney will give local authorities renewed confidence in using Section 20? Would you be willing to give a summary of Williams and Hackney?
Williams and Hackney is a fascinating case on which and I completely disagree. Williams and Hackney, Williams and Hackney is a case where the parents had their children removed from them under police protection, and then they were asked to sign something, or did sign something, to have their children in Section 20, and their children were in Section 20 for 12 weeks, for 8 weeks. And they were in Section 20 for 8 weeks because the parents were subject to bail conditions saying they couldn't look after their children. Parents had lawyers, but the lawyers didn't do anything about the bail conditions. Local authority clearly didn't want to have these children permanently, possibly because it was a very large family. And so they didn't bring proceedings. They didn't take an EPO. And so they were reliant on what probably in non-technical terms was a rather dodgy statement, a rather pressurizing the parents to keep the children in Section 20, but the parents couldn't have the children back because of the bail conditions. Parents then went through all sorts of administrative processes, complaining about this in all sorts of different ways, but eventually they went to court when they'd exhausted all that, and they sued the local authority for breach of their human rights, and they were awarded damages, I think 10K each, at first instance by a non-family judge. The local authority then appealed, and the Court of Appeal said this was a completely okay use of Section 20. Wasn't necessarily brilliant practice, but Section 20 does not require parental consent, and so there was to be no damages for the parents. The parents then went to the Supreme Court, where Brenda Hale gave the judgment. Brenda Hale's judgment's not the best judgment she's ever given. It's a little bit confused, but she held that the local authority what the local authority did was legal. And will local authorities be less willing to use Section 20? If they're less willing to use Section 20, they have to be more willing to use the courts.
I think the question was actually, would they be more willing to use Section 20?
Would they be more willing to use Section 20? Yes, but I don't put it down to Williams and Hackney. I think I'd put it down to Isabel Trowler's paper, where she's stressing the value of the use of Section 20. What the Public Law Working Party, which seeks to perhaps control the use of Section 20, what impact that will have, I don't know. But certainly the DfE is, through Isabel Trowler, is trying to encourage the use of Section 20. And certainly local authorities no longer have to fear, to the extent that they would have done in 2016, the possibility of a damages claim. But that's for other reasons as well.
Thank you. Asks, well, she says she's struck by the pattern of children being reunified at care proceedings end, but then, as you've shown us in your graphs, not afterwards. So the reunification is only at the very end of the care proceedings. She says, we can see children leaving care to the parental home. Are they all leaving immediately post proceedings, or is there a period of interim?
They're mostly leaving at the end of the proceedings or slightly before. So if I've got a hearing and the local authority aren't going to contest, or they think they won't get a care order, they know the child's going home for a supervision order, they might start placing that child at home in the week or weeks before the proceeding. So their reunification plan will start before the final hearing. But we did have children who went home at the final hearing where the local authority was really not expecting this.
Okay.
So there wasn't an established reunification plan. And in the cases, there were a very small number of cases where the local authority was what you might call legally gobsmacked. They appealed and asked for the order to be stayed. And if the child was in care, they could stay the order for the child going home. And one of those cases, actually involving 3 children, was reversed on appeal. And the placement orders were made, which is what the local authority had asked for in the starting point.
But what you're not seeing is children literally going home after the end of the court case.
Yes, I am. They are, a lot of them. They're being, well, they're in care, they're being collected at the end of the hearing and going home, because they're not at the proceedings. Yes, quite a lot of, or they're being collected and going to special guardians who they've not lived with previously.
Goodness.
Yeah, that's what we thought too.
Ryan Wise asks another question, so I'm just going to put that to you later. But asks, were you able to gather any data on the number of children who left care who were previously in early permanence fostering for adoption or concurrency placements?
We didn't have any of those because of when the data was collected. So early permanency or fostering for adoptions coming in, isn't it? 2013, 14, 15. Our samples collected in 2014, 15. It's also pretty rare when it's first introduced. So this is the needle in the haystack issue. I don't even know whether off the top of my head, if our local authorities were using early permanence in second half of 2014.
Right.
Even
Okay.
if they were, it would be unlikely that you'd spot a case because you've not, you've got a random sample.
I hope I pronounced that correctly. Asks, and it's really a rather wide question. Would you say one of the reasons for fewer numbers of children entering through Section 46 is police and external facilities considering family to be a private institution?
I don't think, well, certainly when we did the study of Section 4 of police protection, we didn't get that view. Police were aware it was very difficult to get local authorities to take children. Particularly, a lot of police protection is actually happening out of hours. And so you've got standard case would be a drunk parent who's not able to care for a child because they're so inebriated. And the police officer would say to the child, who normally looks after you when mum or dad can't look after you? And they'd say, I go to my Auntie Betty. So they'd get Auntie Betty's address. The ones that were on top of the job would make sure Auntie Betty had been police checked in some way, wasn't known to the police for nefarious activities, and then they would drive the child round there and send a notification to the local authority if that's what they'd done. So it's more about, I mean, that you could say, well, that's about being a private institution. It's more about how you get a foster placement for a child in the middle of the night. If you can't a child direct to a relative or a friend or a neighbour, you have to take them back to the police station, unless they're really tiny. And tiny children were routinely taken to hospital because you couldn't know if a tiny child was well or not. So, and hospitals would take in tiny children, whereas they wouldn't take in 12-year-olds unless they were obviously injured. So 12-year-olds went to the police station. And police stations don't have any facilities for children.
I know that's been the subject of other reports, yes. Ask second question. He says, does the data track how many supervision orders were given with special guardianship orders?
It does, it does. And I can't remember that off the top of my head, but that's not, I mean, that's a habit rather than something that's taken over. We didn't have hardly any, I think we had one of those cases in our first sample and about 50% in our second sample. And then you find them in certain local authorities and not in others. So it's a local practice. A local practice of the, sometimes pressed for by the local authority, but quite often imposed by the court.
And does it change the nature of a special guardianship order?
Doesn't change it at all, because if you think, how do we see, it's about support. How do we see that special guardians are supported? Because there's a special guardianship support plan and the children in need. And all the children on special guardianship were children in need, irrespective of whether they had supervision orders. So didn't seem to do anything. It didn't seem to do anything, actually. And it could have been a mark that you're not feeling very satisfied about the potential this person as a carer. And certainly there's some stuff in Judith Harwin's study on special guardians that indicates that. Or it could be about support. So is it about supervision or is it about support? And that's pretty random, actually.
Now, this is, I think, possibly a question for the next 20 years, but it's been asked by, I don't quite have a name, but will you or your colleagues ever be looking at private law? There's lots of grey areas there too.
I'm not looking at private law because I've spent the last 25 years looking at public law. There are a whole number of people looking at private law. I did actually design a study looking at the sort of overlap between private and public law. And when we looked at the data, it seemed to be a small and declining practice, but that might be something to do with the data rather than what's going on. And I think there's a study being planned from Cardiff University looking, at least in Wales, on this public-private overlap.
I've got a couple of people asking detailed questions about whether they can have your data. I suggest they probably email you if they're looking for.
Yeah, if you get the research report, there's a link. There's a
data
to the data has been lodged in the data archive, but that it can't be the DfE data. We can't lodge the DfE data because it was part of our data agreement, but we have derived some variables that allow you to do some of the analyses that we did. But the data is in the data archive, and the reference to what it's called is in the research report.
There's a question here. You've obviously and understandably criticised the way local authorities, legal departments do try and capture data. So she asks, what specific software or methods do you think would improve that capturing of data?
I mean, I'm not into the technical aspects. That's not my skill. The key thing that I would want local authorities to do is to include the dates of the beginning and ending of their care proceedings for all children who they look after who are subject to care proceedings, and all children who are children in need who are subject to care proceedings. What the contents of the data, of the main variables, are really determined by the DfE. So if the DfE don't want it, people don't collect it unless they want it for their own particular purpose. And my shout out would be for local authorities to think about the use of proceedings, because once they have the dates of the use of proceedings, they can begin to look at cohorts of their group, cohorts within their database. So they can say, for example, new judge has come. Judge Jeffries has become the designated family judge in our court. What does that mean for the orders made? And they will then have evidence, and they can go back, or they can write to the president of the family division and say, since Judge Jeffries became the designated family judge, we've had 48 hangings of children looked after children, or whatever it is. So I think actually being able to think about the proceedings, not just in terms of the individual child, which is of course what local authorities have to do, but think about the patterns of how they and the courts are relating to children via the proceedings would be really useful.
I've got a question from, she asks, were there children placed on care orders at home?
Not in our sample, because the local authorities refused to accept that. Now, when we specifically interviewed in local authorities about that point, and some of them admitted that they did do that sometimes, but there weren't any in our sample.
What were the variables that they made them feel comfortable to do that?
They didn't have any variables that made them to feel comfortable to do it. They did it because they felt that was that was the only thing they could do. But the point they put in particularly in relation to interim care orders, we're starting proceedings because we do not think these children are safe. How can we say they're safe and leave them at home and be responsible for those children as we would be under a care order? If we have to have those children at home, we're not going to be responsible for them. We'll just have an interim supervision order. And that's the same approach that was taken I think, at the end of the proceedings. Now, what we do know from the Judith Harwin study is that, and from some national statistics actually, is care orders at home are much more common in the north of the country, and we weren't receiving in the north of the country. Yes, it's a northern habit, and it's really questionable. If we're worried about the large number of care proceedings, and we're making care orders at home at the end of the proceedings, one might ask why we needed those proceedings. It's the same question that I would ask where we have all these children who are at home during the proceedings. So they're not looked after during the proceedings. Why are we using proceedings?
One final question from, my apologies if I've mispronounced that. He says, my question concerns the length of proceedings. You told as longer as it is better, the outcome for the child could be. Do you not think it might negatively impact on the child's feelings staying in various accommodations? So I suppose that's the question of, do we go for longer but a greater analysis, or shorter but possibly less analysis?
Well, I don't think longer proceedings are better for children. I think longer proceedings are actually a lot worse for children. They're a lot worse for local authorities as well, in lots of ways. So children who are away from home, who go home, spend a longer period away from home before they're reunified. And that, I think, is problematic. If they're able to be reunified, one has to ask, why, if they're able to be reunified at the end of the proceedings, weren't they able to be reunified earlier? And that was particularly true when we had long proceedings. I think the issue is about whether you can make a good decision with the amount of information you have. And you can make good decisions. I think after ABS, courts found it easier, some judges actually, it's not true of all of them, found it easier to give parents another bite of the cherry. And that language was sometimes, or almost that language was you give the parents another chance, bearing in mind that a large number of these children have been subject to the pre-proceedings process, which hadn't worked. In other words, they'd needed to be proceedings. We then have proceedings, and the court ends up saying, well, parents should be given another chance. So we make a supervision order. And we even have in our sample cases where that supervision order failed, case goes back to court, and the court makes a second supervision order. So there's a whole issue about the pressure on judges to make difficult decisions and the training they have to make decisions that they think are difficult. And if we think about the language, we hear a lot of language about proceedings being draconian, care order being draconian. It's very adult-centric. If I'm an abused or neglected child, those proceedings aren't draconian, they could be life-saving. And the fact that we use that word draconian repeatedly, or the judiciary use that word repeatedly, shows that they're not even-handed between child protection and family protection. They're very much focused on family protection.
Well, thank you very much indeed.